get on the record, please. Thank you. We are now on the record. This is State of Idaho versus Bryan C. Kohberger, case number CR 29-222805. Mr. Kohberger is in the courtroom. Ms. Taylor is representing him. Looks like Mr. Logston is participating on Zoom, as is Ms. Bassett. And we have Mr. Thompson and Ms. Jennings in the courtroom representing the state. Participating on Zoom is Ms. Beatty and Mr. Nye. Also representing the state, I've got Ms. Engler is the court reporter. She's participating on Zoom. And I think that's really everybody that I have to address here. So the defense, Ms. Taylor, requests a status conference for today. So here we are. Go ahead.
Thank you, Your Honor. Your Honor, we asked for this status conference today because I have had some opportunity to meet with Mr. Kohberger and talk about his trial date and his speedy trial right. Your Honor, we're here today to ask the court to continue the trial setting, and Mr. Kohberger is prepared to waive his right to a speedy trial. Your Honor, there are a couple of things that I need to place on the record. One can come after the court takes his waiver, but one I think ought to come before the court takes his waiver. Your Honor, as the court knows, we will file a number of motions to strike the death penalty in Idaho's scheme of capital punishment. Because we're here today to waive speedy and ask the court to continue, I think the court and counsel ought to know that one of the motions that we will be filing is a motion to strike the death penalty because it places Mr. Kohberger in a position where he has to choose between two rights. One, that being the right of the speedy trial, or the other right to effective assistance of counsel. I didn't want that to come filed later and have it be any surprise that I knew it was coming. It will be coming. That motion will be coming. And for us to stand up and request a continuance and waive speedy today. The rest can be placed on the record after the court's questions, Mr. Kohberger.
Thank you, Ms. Taylor. Well, you heard all that, Mr. Kohberger? Yes?
Yes.
And is that the case that you want to waive your speedy trial rights?
Yes.
Do you understand that those rights are statutory in Idaho, also protected by the United States Constitution and the Idaho Constitution?
Yes.
You understand that if you waive, you're waiving really forever in this case. So if we were to push this out, this case, and then something else happens that allows us or requires us to push it out a little farther, you can't claim your right to a speedy trial at that point. You understand that?
Yes.
So have you had enough time to discuss this with Ms. Taylor?
I have.
Is anybody pressuring you to waive your speedy trial rights?
No.
Okay. You sure you want to do this?
Absolutely.
Okay. Do you agree with this, Ms. Taylor?
Your Honor, I do agree with this. I do not believe counsel can be effective by October 2nd. In either phase, if we should end up in a part 2 of this trial, our investigation is not complete. Our work with experts is not complete. We haven't completed our review of the state's evidence. I do not believe that we can be effective by October 2nd.
Thank you. Is Mr. Kohberger willing today to write, to sign his name and you to sign your name on a waiver of speedy trial?
Your Honor, I can tell you that I did not prepare Mr. Kohberger for that, and that would be because I am not familiar with this court's practice. I expected we would waive in open court today, and that would be sufficient. I'd be happy to take a look at the full process to represent.
Well, I wasn't really anticipating this, but just in case, and hypothetically, I grabbed a Odyssey form, which I don't really favor those forms, but I did pull that out, and maybe I could give this to you and Mr. Kohberger, and you could take a look at it. My practice is always to get a written signature of waiver in any waiver of speedy trial. So let me go to, and I haven't taken his waiver yet. I'm going to notice that, but I just want to let that settle for a second. Mr. Thompson, do you have any objections?
No, Your Honor. I mean, I think everybody would like to have this resolved sooner than later, but I think the case is of such great importance and complexity that this is a smart move.
Thank you. I do agree with that. I mean, we have so many things going on. There's a lot of issues left to resolve, and as you know, I mean, you probably would understand that, and you were all thinking this, that it's going to be very difficult to put everything together that needs to be put together before October 2nd. This is a very significant, complicated case for all the lawyers, and particularly for Mr. Kohberger. And so I understand you want to be fully prepared for the trial, and if it happens, also sense. So, and likewise for the state, likewise for the court. I mean, I was willing to do that, but you don't want to be half-baked in any of these issues, because they're all important. So, I don't know, did you take a look at that form?
Maybe have just a moment.
Yeah, go ahead. Thank you. So, Mr. Kohberger, did you read this over?
Yes.
Okay, what I'm talking about is the written waiver of speedy trial.
Yes.
Did you understand the terms here,
Yes.
which we've already talked about?
Yes.
And you agree with the signing of the form waiver of speedy trial, Ms. Taylor?
I do not.
Okay, so Mr. Kohberger, do you want me to accept your waiver?
Yes, I do.
Okay, and you understand that if I accept your waiver, you're giving up your constitutional right under the United States Constitution and the Idaho Constitution on a constitutional right of speedy trial?
I understand.
And you understand that if I accept your waiver, you're also giving up your Idaho statutory right to a speedy trial?
Yes.
And that is within 6 months of your arraignment.
Yes.
And you agree with the tender of the waiver, Ms. Taylor?
I do not.
Kohberger, do you want me to accept the waiver?
I do.
Based on our discussion, your waiver of these rights expressly in court and also in signing this waiver of speedy trial. Also, you are tendering these waivers on advice of counsel. I will accept your waiver of speedy trial. I find that your waivers are knowing, intelligent, and voluntary, and there's actually good cause to recognize that, given what I heard from your counsel, Thompson, and my findings as well. So, with that, we can talk about resetting this. I'm prepared to do that today. Sarah?
Your Honor, I would say that we are not prepared to choose the trial date today. That brings me to the second part of what I wanted to talk to the court and counsel about today. We currently have September 1st as the date for the motions to dismiss the grand jury indictment. Our deadline to file our challenges will be today, and we're prepared to file those today. Our hope is that we can keep that particular hearing date. We'd like to keep it both to challenge the grand jury indictment, and also there are 2 additional motions that we're going to be filing, and we're hoping that we can have those heard. After that time, after we've heard the motions, we'd be in a position to meet with the state if we desire and talk about a reasonable trial setting. My preference would be to have us discuss that and reset the trial one time and not do this a number of times and worry about getting subpoenas out and worry about calling. That would be my request. The other deadlines that are in place right now on the court's scheduling order, I think those would be appropriate for us to talk about the state and the defense, and perhaps suggest for the court to order a different scheduling order than the one that exists. We just simply want to keep the grand jury indictment challenge date because that's soon, and having the court's decision on that will largely impact what comes next. If the court will allow, I'd like to briefly address the other 2 motions that are coming that have not been filed today.
Sure.
Okay. Your Honor, we will be filing a motion as to deal with media in the courtroom, particularly the cameras in the courtroom. And that motion should be filed by the end of today or first thing tomorrow. That comes from some things that happened last week when we were. The other motion, Your Honor, has to do with what happens to witnesses that the defense might call. The court will recall we had Gabriela Vargas testify last Friday in our hearing. Last night, she was visited by 2 FBI agents and interrogated about her testimony and the timing of her declaration. That, in our view, impacts Mr. Kohberger's due process rights and his rights to effective assistance of counsel, and that motion will also be filed later today or first thing tomorrow.
Any objection to hearing this here, the motion along with these 2 more motions to be heard on September 1, Mr. Thompson?
I don't believe so, Your Honor, having not seen exactly what the motions are, but understanding they're fairly straightforward. I would think that we could, if we look at the motions, we have an issue with raise the support of Ms. Taylor. I will, for the record, since Ms. Taylor has brought up the situation with Vargas, give court and counsel background. Over the weekend, Ms. Vargas, after she testified, engaged in some electronic communications with others in the genetic genealogy field. Those indicated, as it was reported to the investigators, to our investigators, that she was redigging on some of the things that she testified to in court. When we heard of that, I reached out to the investigators and said, can we find out what's going on? And the FBI indeed undertook an investigation. And preliminary reports are that Ms. Vargas claims that some of what was in her declaration She inadvertently agreed to her sign without fully reading it. We're documenting that so we can expose it to Ms. Taylor and to the court, because I think it goes directly to what happened last week. That's the only reason that she was contacted, because it was reported to us that she was retracting some of what she had testified to and what was in her declaration. And we felt in fairness we needed to uncover that quickly. There was no other motive, no other motivation for this. I just wanted to candid with the court.
Thank you, Mr. Taylor, for your response.
Your Honor, that's certainly different than the information that I received.
That's how we sort these things out.
Here.
So,
Your Honor, that's certainly different than the information that I received. I would have been happy to be advised about that, but I'm not sure that's accurate. I mean, I'm sure that's what Mr. Thompson heard. I'm not standing here calling him a liar, but the quality of the information he's received, I'm not sure that's entirely accurate. My hope is that these two FBI agents that were at Ms. Vargas's home last night, hopefully they recorded everything that they talked to her about, and that should resolve the issue of that.
okay, great. We'll hear about it at the hearing. That's how we sort these things out.
Here.
So, back to a change of the scheduling process, or scheduling order. I mean, I think it does make some sense to redo that. You want to just talk about that before we start taking that apart? We don't have to do it right now, I'm saying.
Judge, the state's position would be is that the court vacate the October trial date, vacate the scheduling order. Let us get through what we're going to do on the 1st, and then let's